You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on the docket today is Pino versus the Bank of New York.
Please report you turn your mic around? Good.
There has never been a matter of greater public importance than this court's obligation to deter fraud and defend its integrity. The rules which guide our profession and our courts should never be interpreted in a manner which allow a party to shield itself once it has attempted to commit fraud on our courts. The issues of fraud facing our courts today call into question the very foundations of our legal system.
All right, let's appreciate all those very lofty statements. Let's talk about the facts of this case. Sanctions were sought pursuant to 57.105, alleging the assignment was fraudulently backdated. Under 57.105, which is a statute, not a rule, is there a 21-day safe harbor period?
There is.
And in this case, wasn't the case dismissed by the plaintiff through Rule 1.420A within that 21-day period?
Not only was there a 57.105 pending at the time, there was also a motion to dismiss based on the backdated assignment of mortgage.
No, what I'm asking you is under the sanctions that you sought under 57.105 was within the 21-day safe harbor period.
I don't think that fact is in the briefs, but I do believe that it was dismissed within that 21-day window.
All right, and so what I'm concerned about, because this case has been resolved, and the respondents talk about anything we would consider doing should be prospective, is what is, and this is, again, of course, greater than just what goes on in the mortgage foreclosure area. This would affect any plaintiff who desires to dismiss their case before it goes to the jury, is what is the rule that you are seeking for this court to adopt going forward that would be consistent with the language of the rules and our precedent, or are you asking us to recede from precedent?
What we are asking this court today to do is uphold the foundations of our system. We appreciate that, and there are countless cases that involve, like, for example, here, if the mortgage, if there had been a foreclosure and the foundation was a fraudulent document, the homeowner could come in within a year and move to set aside that foreclosure based on the fraud and the affirmative relief that was obtained. Correct? Correct, Your Honor.
All right. So we have mechanisms in place. The attorney who was perhaps responsible for this has been reported to the bar. We have sanctions that courts within their inherent authority can grant. But what I thought you were asking for in this case was that you waited 5 months till a new foreclosure action was filed, and then you sought in the dismissed case to resurrect that using Rule 1.540B3. That is, you didn't seek relief in the case that was refiled, and there may be some question about whether you could have gotten relief in that new case based on the prior fraudulent documents. But what you were asking the court to do was reopen a case that had been voluntarily dismissed, and then to dismiss that case with prejudice.
Absolutely.
Not so that this homeowner would be able to keep his home, and that would be not necessarily a vindication of the court's authority, but really relief for this particular homeowner.
No, Your Honor, I disagree. It would be relief for the courts. And what we are asking is that
But you're not, I just want to make sure so we know, you're not asking for attorney's fees and costs.
Absolutely not, Your Honor. The 57.1.5.
So you're not concerned with those, because those are usually the traditional sanctions that are sought outside of something where there's been abuse during a lawsuit. There are sanctions that can be had, including striking the pleadings. So there's lots of mechanisms that currently exist to impose sanctions. But what you're really asking us to do, and this is where my concern is, you're really asking us to change the way the rule on voluntary dismissal operates.
What we are asking, Your Honor, is to, within the plain meaning of 1.540, not prevent the courts from having the power to address fraud. Because if you think of it in the alternative, if this court is to answer the question in the negative and not give the courts the power and the discretion to address fraud that they've used the voluntary dismissal to shield themselves from, it sets up a system whereby every litigant who comes before our courts has not only been condoned but encouraged to lie, to cheat, to steal, knowing that if they are caught, they can simply voluntarily dismiss and absolve themselves of that fraud.
Well, let's go back to you've been discussing the rule. Could you also address the common law theory of courts vindicating rights and the question of whether there must be some showing that the party who has engaged in that conduct has gained some affirmative benefit from it? Is that part of it, or is that not part of it?
It should not be a part of it.
I'm asking whether the common law doctrine requires that as part of the element in vindicating courts' rights. That seems to be, you keep going back to that this is really not a rules case, is it?
Well, the common law doctrine is a little bit different than the fraud exception. The common law doctrine requires a showing of some sort of prejudice or some sort of investment in the case.
Exactly.
But the fraud exception is where I believe the court has the power, and that's an exception they have carved out, recognizing that under the plain meaning of 1.540.
And that's different. That does not carry with it. That does not carry with.
Absolutely different.
Just finish the question. It does not carry with it a requirement of prejudice or affirmative relief. It requires nothing at all other than fraud in the air.
It does not. To the extent that the courts have interpreted this requirement of affirmative relief, it's nonsensical. And if you look at the lower courts and you look
saying something is nonsensical, I understand that there are some things that have happened, on a grand scale, that it should be an embarrassment to an industry, to the legal system, and your firm, in terms of uncovering what happened here, appreciate that. But let's not, when you use words like nonsensical, I think you offend what we're trying to do here, which is try to be faithful to both the principles that you want to vindicate, but also make sure that we're faithful to both the common law, the law, and the rules. And my concern is that Rule 1.420A, which allows a voluntary dismissal very liberally, and much more liberally in terms of time than the federal rules that only allow it up to time an answer is filed. But our state, since the 60s, have said no, it can be up till the time of, the jury is sworn. Now you get to Rule 1.540B3 that says that you can use that rule to relieve a party of a judgment or a proceeding, relieve them. Now, that's where the idea that there has to be something to relieve the party of. Most of the time when a defendant has a plaintiff who says, I'm dismissing this case, they're happy with that. They're happy that they've been relieved of the lawsuit. So that is why those cases that talk about relief mean that if it's got to be that somebody obtained some relief, that then the court is setting aside. Here, you would want us to interpret affirmative relief being that any time there's a fraud on the court, that would be enough of a reason to set aside a dismissal under Rule 1.420A. That's essentially what you're saying? Is that correct?
That is correct.
Okay, and you're looking, would you agree that that's not, we would have to rewrite the rules in order to come up with that interpretation?
Absolutely not. The Miller Court has already interpreted that a voluntary dismissal is a proceeding which the
court
may
agree about the proceeding. I don't think your problem is with the proceeding. I think the problem is the word relieve a party, and that's where, when Justice Lewis was asking you about the words, doesn't there have to be some affirmative relief obtained? We have no problem if this had gone to judgment that there would have been something to relieve the homeowner of, correct?
If the court is going to adopt the requirement for affirmative relief, and that's different than relief under 1.540, the courts have adopted this term affirmative relief, but they haven't defined it. And if the court is going to interpret that as a requirement, then it must interpret it in the broadest possible sense, which is a benefit to the party. And shielding yourself from acts of fraud is always a benefit. Bank of New York Mellon relieved themselves of potentially getting this case dismissed with prejudice, potentially having sanctions equal to or greater than the mortgage.
But if, what I'm struggling with here, if there was a problem with the paperwork here, and the suit is dismissed, and it goes away, I don't see how your client is prejudiced by that, because it's gone away. And it seems like to me, you're just looking for a gotcha to get out of the mortgage. Am I wrong?
Absolutely wrong. This is about a bank.
But let me, okay, I thought that'd be your answer to that, so I accept that. Are you here authorized by Roman Pino? Are you authorized to be here on his behalf?
Absolutely.
Okay.
Let me go back to the question, though, about the relief. I didn't, and maybe this would have, maybe the issue of whether these cases should have an evidentiary hearing to develop it, because we really don't know. We know your allegations. We don't know the truth. I didn't detect, though, any allegation that the Mellon Bank of New York did not have the authority to bring the lawsuit to foreclose on the mortgage. In other words, that somebody else actually either owned or was assigned the mortgage. This is, and we don't really know how this one happened. We know that the Stern firm had hundreds of employees and was representing this bank. And so is there any allegation that they were not the proper party to foreclose on their mortgage? Any allegation that Mr. Pino was actually not behind on his mortgage payments? Anything at all of that nature in this case?
The fact that Bank of New York Mellon had to manufacture an assignment to establish to the court that it had standing should raise a red flag with this court. And if you look at the evidence...
What I'm asking you is further. We don't know, because we don't have the record developed, as to whether someone else actually owned or was assigned the mortgage. Do we know that?
What we had before the court and the allegations that were there is that Bank of New York Mellon was owner and holder by virtue of an assignment. Now, the allegation was that that assignment was fraudulently backdated. The only other evidence before the court was an endorsement specifically to Countrywide. They had no other endorsements, no other evidence. But this is not about Mr. Pino. This is about the bank and the fraud that was committed.
Well, it seems to me that really this is about Mr. Pino. That what you're looking for really is an opportunity for Mr. Pino not to go back to court, because has Mellon Bank now cured the problem that was in the first case?
You can't cure fraud. Once you filed the fraudulent document, it's there forever. You can't simply say, that was fraudulent.
The document that has now been filed in the new lawsuit, is that a fraudulent document?
This court will never know the facts of how deep the fraud went. We only know the tip of the iceberg, and that's exactly why we're here, because the court below mistakenly believed that its hands were tied, and it didn't have the power or the jurisdiction to find out, to have an evidentiary hearing.
Can the fact of what was the document that was filed in the original suit, I assume you cannot litigate the validity of that document in the new lawsuit?
And that's a problem. There is one case out of the Florida...
Is that true or not?
I don't know, because there is one case...
Of course you could bring out in the second lawsuit that they had a question about the assignment, and question that as far as the credibility of whether they actually have that assignment or not. And seek, I don't know why you wouldn't be able to seek sanctions in that second lawsuit if they were seeking to foreclose.
There is a Florida Supreme Court case, Walrath versus TGI Friday, which stated that misdeeds of a party in the first case cannot be raised in the second case. I'm not saying that this court shouldn't give options to the parties. They should have the option not only to bring it in the first case, to bring it in the second case, to bring it as an independent cause of action. If that is going to be the court's stance, they need to be very clear about that, because there is that Walrath case out there.
But I'm having trouble understanding the concrete material harm to Mr. Pino. Now, we know this lawsuit has been settled, so this is all moot with respect to him. But assuming it had not been, and assuming we weren't dealing with a purely hypothetical issue here today, what would, once that lawsuit, the first lawsuit is dismissed, I don't understand the harm that your client has endured if, in fact, the bank has the right to foreclose. That just escapes me. Now, maybe there are costs associated with the first lawsuit that you would be entitled to recover. I don't know. That's a separate issue. But that's not what you're looking for here. And I just don't... Now, I understand there's an interest in vindicating the judicial system and the judicial process, and I don't disagree that people should not come into court and file papers that are fraudulent or are inaccurate or untruthful. Okay, and there are ways, as Justice Periente has pointed out, there are ways to deal with that. But as to, in the context of a party such as Mr. Pino, I'm having trouble understanding what you've got a right to recover for.
Mr. Pino was denied the opportunity to have the case dismissed with prejudice right then and there. The parties were there. The evidence was there. This case is a prime example of why the court should deal with it in the first place. Now the law firm of David Stern is defunct.
Was that his argument? Was that the argument that Mr. Pino made at the there was some kind of hearing at the time of the dismissal, correct? And was that his argument that this case should be dismissed with prejudice? I thought his argument was we need to have an evidentiary hearing about this.
The argument under 1.540 was that we had established colorable entitlement by showing that the firm had created, had filed, had relied on an assignment of mortgage, which if those court found those facts to be true, there really was no other explanation than they manufactured evidence to prove their case.
But you were
so
concerned about the voluntary dismissal. How many months did you and your client wait to actually seek to set aside the voluntary dismissal?
After the plaintiff was caught red-handed with fraud, we never thought that the plaintiff would bring that case back again. And when they did, we filed the motion to vacate to the court, stating that it should have the power to bring that case back and sanction them right then and there. Why should the litigants restart the case, refile, begin the litigation all over again, and give them the opportunity to manufacture a brand new assignment of mortgage? This is more than just...
Well, now, if the new one was manufactured, then that's the defense in the new lawsuit.
But you can't fix fraud. The court gave the banks the privilege of taking a voluntary dismissal.
Well, it just seems to me that if the new one is a fraudulent document, that you can argue that not only is this one a fraudulent document, but you see they did this before, and that's why this case should be dismissed with prejudice totally. I mean, what's wrong with that kind of argument?
And I'm not advocating that a litigant shouldn't have the right to bring it in a second case. We'll never know. We'll never know what would have happened in the second case.
And it seems to me you might be entitled to fees for all of this if you, in fact, prove that, correct?
But it's all about the court having the jurisdiction. If the court wants to rule that they'll have the right to bring it in the second case, it needs to do so clearly because of the Walrath case, which does seem to state that you can't bring it in a second case. So I'm not advocating that you can't.
Which case is that again?
This is Walrath versus TGI Friday. I don't have the site before me, but it is a Florida Supreme Court case which states that misdeeds of a party cannot be raised in the second case. I'm not advocating that you can't. What I am advocating is the court should at least have the option of bringing it back in the initial case for the sake of judicial resources, for the sake of expediency, for the sake of the fact that...
Did you cite that case in your brief?
I would have to take a second glance. I'm not sure.
I don't see it in your brief.
I believe it was cited in the motions below. It's in the record. I'm not sure if it's in the brief itself, but it was cited in the motions below. But this is about the court having options. The rule allowing voluntary dismissals was never intended to be used in a manner for a party to shield itself from fraud.
You have now exhausted all your time. So you have no rebuttal time left. I will, however, give you a minute of rebuttal.
Thank you.
May it please the Court, Bruce Rogo, William Heller, and Catherine Giddings for the respondent. The question in this case, and it's a question that applies to the wide universe of civil litigation, not just mortgage foreclosure, is can a party who is not harmed and where there has been no affirmative relief obtained set aside a notice of voluntary dismissal under Rule 1.420?
Well, let's talk about what, first of all, going forward. We adopted after this case a requirement that these pleadings be sworn and under Rule 1.110B, and stated the purpose was to give greater authority to sanction mortgagees who make false allegations. We said that.
Yes.
But we really didn't give a mechanism for how that sanction would work. So going forward, I think there is a grave concern that the plaintiffs who were foreclosing on mortgages, whether I thought it was just, robo-signing, which would be different, this looks like actually a fraudulent document that was used for an assignment, a blatantly fraudulent document. And so going forward, how do you see Rule 1.110B working, Rule 1.540B3, or any of the other mechanisms, so we can give some clear guidance as to what would happen or what should happen in this situation going forward?
If, for example, someone verified a complaint and that verification was false, then the court could impose sanctions upon the person who verified.
But our rule works where if after somebody catches it, which for many homeowners who have no ability to hire a lawyer would be extremely rare, but if someone catches you, there is the mechanism of Rule 1.420A that just says it can be dismissed, and that there is a great concern about why shouldn't the court have the authority to order an evidentiary hearing, and then under extreme cases consider whether, including all factors, as the plaintiff says, including judicial integrity, deterrence of future fraudulent acts, whether the fraud relates to a central issue in the case, determine that the dismissal has to be with prejudice, not without prejudice.
Well, I want to separate two things. In terms of 110B and the verification requirement, if there is a verification of something that's false, then there could be an order to show cause why the party shouldn't be held in contempt.
But how can that happen even after the once they're caught after a dismissal?
Yes. Yeah.
You agree there has to be continuing authority of the court to impose sanctions.
Absolutely. There's that sanction. There's a sanction of a referral to the Bar Association, which would be another sanction. There could be fees imposed in the second case if a second case is brought where there's a contract, as there is here. So there are sanctions that can be imposed. We're not saying that there should be no sanctions if indeed there's been a submission to the court that is an improper submission to the court. But what we are saying is that a party who hasn't been harmed cannot, and where there's no affirmative relief, cannot seek to undo a voluntary dismissal. And that's really what this case is about. And it does not apply just to mortgage foreclosure cases. It applies across the board.
Well, do you agree? I don't know about the case she's mentioned. I had assumed that in the second case, that first of all, if the costs aren't paid of the first case, right, there has to be a payment of costs before the second case can go forward under our rule.
Where there's a contract that calls for that, as there is in this case, and the Fourth DCA acknowledged that in its opinion below, yes.
I thought costs under Rule 1.420D would exist even if there's not a contract. Costs, not attorney's fees.
Well, D does talk about costs, and costs includes attorney's fees, and that's what the Fourth DCA talked about.
Okay, so that can be brought, the requirement that there be a payment of costs can occur in the second case?
Certainly where a contract calls for that. And,
would it make sense in terms of going forward to look at Rule 11 and see how that is operating and see whether this court should be doing something similar to Rule 11, which is the 21-day
safe harbor
period?
Well, we do have a safe harbor period anyway under 57-105. But I think if the court is thinking about, well, under D, if there's a voluntary dismissal, even if there is no contractual agreement to pay costs in a case, that a court could consider that. That would be a change in the rule, and that could be addressed. But the important thing here is that the notice of voluntary dismissal rule has long been established. I mean, really since Randall Eastern, and it's interesting under 1.540B. A party seeking relief has to show that they have been harmed in some way. And when you look at 1.540B and the language, a party may be relieved, can be relieved of a proceeding, and this is a proceeding under Miller, we agree. But here are the elements. In each of the elements, the party seeking relief has been harmed. I mean, in Miller and Randall Eastern, the party seeking relief was the party who filed the voluntary dismissal and then realized it was a mistake to file the voluntary dismissal.
Do we need to define, though, if we choose to go that direction, what harm means? By what are we talking about? We say have to be harmed. I mean, you can have theoretical harm. It's harm to the system. You've had to defend the case up to that point. How would you define, if we are defining harm, how would you define that?
Where the party who is voluntarily dismissing has taken something of value from the other party, from the defendant.
It's more than just a theoretical harm.
Yes.
Involved in litigation harm. It is actual affirmative relief.
That's right.
Type harm is what you're saying.
Well, I mean, it seems to me by using harm, we're changing the language of the rule. I'm more comfortable with keeping it as that there has to be something to relieve the party seeking to set aside the voluntary dismissal. So that's why that service case from the 3rd District, there had been, the defendant had gotten an injunction. There was something to relieve that party of.
That's correct.
So really the rule itself already speaks in terms of relief. I think the question is whether you can be relieved of fraud, and that's how they're posing that the rule allows it because either side can obtain relief, and where somebody has been harmed by fraud, but that's something you can relieve them of.
Of course, their argument isn't really that they have been harmed by fraud, but that the court system has been harmed by fraud. I mean, that's what we hear clearly from them. And we acknowledge that the court system does have an obligation to address fraud. But the point I'm making is there are other mechanisms to address fraud.
Well, one is the civil rules provide 1.150 has a mechanism to strike sham pleadings. You can file a motion, and then the court can set an evidentiary hearing before even there's some kind of trial in the whole case. Was something done like that in this case? Was a motion filed?
It was not. And indeed, Justice Polston, that in one case in which there was a motion to strike as a sham pleading and it was granted, the voluntary dismissal that came afterwards was found to be too late. I think that's the Vinoli case.
Well, wait, but let's, in this case, it's not like there's clean hands on the part of what was going on in prosecuting this lawsuit. They initially filed a motion to dismiss because the note hadn't been attached or the assignment.
The assignment.
And instead of initially attaching something, you filed a motion against them, not you, obviously, but for attorney's fees, saying that was bogus what they were asking. And their motion back is very detailed about what they said occurred. And it is really a shocking allegation that what happened then is an amended complaint is filed and a document is manufactured that purports to be an assignment. I mean, if it wasn't necessary to have that assignment to bring the case, then somebody was trying to perpetrate a fraud for no reason. So this is not exactly like they didn't do everything they could do to try to bring this to the attention of the court. So I'm not sure if, in terms of answering Justice Paulson's question, I mean, they were vigorously trying to bring to the court's attention that a fraud had been committed, correct?
By the law firm.
But we don't know at this point, right? We don't know if it was the law firm or if it was the bank. We don't know that because there was never an evidentiary hearing.
No, but the allegations are clear, and that's 71 to 73 in the appendix in pages 4 and 7 of our Exhibit B, which makes it clear that all the allegations are with regard to the law firm. I'm not saying that is a critical distinction in terms of my argument. It's not. My argument is a simple argument. The integrity of the voluntary dismissal rule and the ability under 1.540B to set aside a properly filed notice of voluntary dismissal. Their argument is that even though there's no harm to them, even though there's no affirmative relief that has been obtained, the court still has the authority to do that. And the case law is absolutely contrary to that. If that were going
to me, their argument, at least a part of it, is that the harm to them is that now, after making all these allegations about what this fraudulent information that was given to the court, now they're going to have to go through all this again. Basically, that's why they're asking for the relief of a dismissal with prejudice, so that they don't have to go through all of this again and try set depositions that were, they didn't get to do those depositions because your client filed the voluntary dismissal. So is that, I guess the question in my mind, is that the kind of relief, the fact that now they have another opportunity to bring this suit, the kind of relief that we ought to be looking at?
And Justice Quince, my answer to that is no, because the voluntary dismissal rule addresses the ability to dismiss, and within that, of course, is the fact that you can be sued again under the voluntary dismissal rule. People file lawsuits, something happens, they decide this is not a good lawsuit.
But does the court have the authority? If a party files a motion for a voluntary dismissal and the other party says, no, this should be a dismissal with prejudice, does the court have the authority to then say that, or do you get to withdraw your voluntary dismissal? How does that work?
If it were a motion for voluntary dismissal, the court would have some say, but under our rule, it's a notice of voluntary dismissal, and the court has no say in those situations.
So there's nothing that can be done about that.
There's nothing that can be done, and this has been established for years in Florida, and the result is that, yes, there could be a subsequent suit filed, and so the inconvenience of having to face a subsequent suit is built into the system.
I guess I just want to make sure that, but do you agree, though, in the second suit, that if, for example, there were discovery abuses, all this was happening, and right before the court was getting ready to, the defense has now caught the plaintiff doing all sorts of things. I mean, this could occur with personal injury plaintiffs who have, say, filed fraudulent medical reports. So we're not just talking about or something where they've now caught this plaintiff doing something else that's fraudulent, that if it's now dismissed and it's refiled, that all of that occurred in the first suit can be carried over into the second lawsuit.
Yes, I agree.
Because she was saying something about some case that says that couldn't be, and I can't imagine that it couldn't be.
Credibility, if you're going to have to put on evidence of somebody who signs documents and does things like that, it seems to me that the credibility of that person could be attacked with prior inconsistent acts that the person has done. So I'm not familiar with the TGI Friday case it was referred to, but in terms of general practice, it seems to me that's an evidentiary issue, and it would be relevant.
But it does seem that there is the problem, which is that you have been now jerked around for, say, 2 years by, again, it's a defendant that's been jerked around, hasn't shown up for depositions, and now we're on the verge of, for the defendant, insurance companies that have now got this plaintiff, and to get a dismissal with prejudice or other sanctions, and we still allow that those voluntary dismissals to go forward without any vindication of the attorney's fees and costs that could have been imposed because of those abuses.
It is true in Ormond Beach, the Ormond Beach case, it was a 10-year piece of litigation starting in bankruptcy, and there was a voluntary dismissal, there were offers of judgment made, and the court said that's not enough. The notice of voluntary dismissal stands on its own. Service experts with several years of litigation.
It seems to me, and that's why going forward, that the federal rule might be, maybe we've gone too far the other way, but that's not for this case, and I understand that.
And I think, Justice Pariente, that really we have not had the problems. I mean, this has gone on. This is, because it's a mortgage foreclosure case and because there are a lot of those cases, it has attracted a lot of attention. But I think we have to look at this in the universe of general civil litigation. And this has not been a problem in general civil litigation. People have lived by it. The common law exception of affirmative relief has provided an option if that is necessary. And so there needs to be no change in the law.
Well, would you say two things? First of all, if the ICE firm hadn't defended, Mr. Pino couldn't afford the defense, and had gone forward, and then within a year had found out that the assignment had been fraudulent, could this mortgage proceeding have been set aside on the grounds of fraud under 1.540B3?
No, because the assignment was not really necessary in terms of obtaining the mortgage.
Assuming that it was necessary, I've got to predicate on that it was fraud and they obtain relief because of the fraud, it can be set aside, correct? If you're assuming, because if there
had been a foreclosure, if it had gone through the whole process and been finalized, and then you came to 1.540B3 under fraud, and the party had obtained relief against you, and you'd been harmed by that relief, yes, you could come back in.
So the concern is for anybody who has a mortgage foreclosure, and there may be fraudulent documents, there's some risk out there to those that held those mortgages if they use false documents to obtain a foreclosure.
Would it have to be material?
Yeah, it would have to be material, and again, my concern is that it's too broad a statement because the assignment in this situation is not material to the mortgage foreclosure. But the point is that the way you have categorized it, it would be like any civil case. If something material...
In terms of this, so you're saying this is much ado about nothing. They created a fraudulent document even though they didn't need an assignment to foreclose, even though they didn't have the note?
Well, I don't...
And they could just create it. They didn't need to even create this assignment?
First of all, I don't say it's much ado about nothing because I recognize
it seriously. Well, but you just said it's not even material to standing to bring the mortgage foreclosure case?
The mortgage banker's brief, the amicus brief, has set out the fact that we are a lien state, a UCC state, and the assignment is not critical to this. But again, that's not part of the argument today. It's not part of the issue before the court today. But I think that what's important is that when we're looking at general civil litigation, I'm not trying to minimize the mortgage foreclosure issues in the state, but we're looking at an issue that arises in general civil litigation under two rules, 1.420 and 1.540B. And those two rules have to be looked at together, and the cases that have addressed the issues. And clearly under those cases and the circumstances here, there is no basis for setting aside the voluntary dismissal. There are other remedies for fraud, and we support those other remedies for fraud, obviously. A complaint to the Bar Association with regard to lawyer misconduct, if it's lawyer misconduct, and this court has been rigorous in enforcing the rules regarding rules of professional responsibility, contempt, the sanctions, a verification, and you asked Justice Pariente about going forward. The verification requirement in subsection B puts a plaintiff on notice that what he or she files in those situations must be accurate. So the court has begun to address that, or did address that, and then going forward, the courts do have the authority to impose sanctions in those cases.
But the sanctions would be limited if after the fraud is discovered and it was a false a false verification. Once it's discovered before the judge can hold a hearing, there can be a voluntary dismissal.
Yes.
But would you say then there's continuing jurisdiction to impose sanctions? Sanctions other than not allowing the dismissal, attorney's fees, and a consideration as to whether that would go forward into a second refiled lawsuit?
Well, I think the second refile lawsuit cannot be stopped, and I think that the other sanctions could be imposed, which to me would inhibit the kind of conduct that the court is concerned about. But you can't do it by taking these two rules and making them do what the petitioner in this case wants them to do. And so for those reasons, we think that the fourth DCA en banc decision should be affirmed if the court decides to maintain jurisdiction, the jurisdiction that it has taken in this case. And if there were to be a change, obviously it would have to be prospective only. Thank you.
Recognize that I only have 1 minute, so I would like to. One, this court should not delegate the responsibility to deter fraud and police fraud to other branches of government and to other governmental agencies. Secondly, with regard to the Select Builders case, I believe this court has misinterpreted the facts of that case. In the Select Builders case, the injunction, which I believe Justice Periente referred to as the affirmative relief, had already been vacated at the time of the voluntary dismissal, but the court still thought it was of the utmost importance to vacate that voluntary dismissal to deal with the allegations of fraud, so there was no affirmative relief. Secondly, I sat here yesterday and watched Justice Periente talk to a young gentleman about the fact that most people can't afford attorneys and most people can't have attorneys. And we are dealing with a situation where there are great inequities between the parties, a multi-million-dollar corporation and homeowners who won't have the wherewithal or the resources to continually fight these cases year after year after year when the court allows them to refile these cases. That is a benefit to the bank, and that is a burden, a tangible burden to these homeowners. And lastly, there is a very big difference between a dismissal with and without prejudice. This court should have the authority to dismiss a case with prejudice, and that was a point that was raised in the banker's brief, and that was a point that was raised in the court should have the power. The rule regarding voluntary dismissals was never intended by this court to be used as a shield, and because it has been given to the parties, this court should have the power to take it away when it is abused. In conclusion, I ask this court to answer the question.
We thank you both for your arguments. We'll now move to the second case on the docket, which is McLean versus Atwater.
May it please the court, counsel. For the record, my name is Martin McLean. The issue in this appeal today concerns the investigative fees in the case of Thomas More, where they exceeded the $15,000 statutory cap that appears in 27-711-6.
I know you love to litigate these issues, but my question is to sort of question why you couldn't, or why the department couldn't say that that some of these expenses are under the miscellaneous expenses. In other words, and I didn't look at the breakdown of the bill, but had you already exceeded the miscellaneous expenses portion?
No, Your Honor. My understanding, we have not.
I mean, if you had to have your investigator testify, and a lot of this was because for some reason this evidentiary hearing was delayed 5 years, and so that really because of that you had to have your investigator go back. Why couldn't the agreement just be that this be under the subsection 6?
Frankly, that's something that had not occurred to me. I had just assumed, and part of it is sort of, I deal with the Department of Financial Services frequently, and just sort of the understanding that I've developed with them in terms of the billing, the fees that an investigator charges for his work fits in 6. Miscellaneous fees are 5, and there's a whole bunch of things that goes in there. And so I had just accepted that this was the appropriate.
I think it's the other way. 5 is investigative and 6 is miscellaneous.
Right.
But in this case, what you're saying is that the judge, by saying that there was nothing extraordinary about this case,
yes,
or misunderstood because it was, quote, a normal post-conviction case, and failed to consider what were the extraordinary circumstances of the, let's say, I guess the differences, what the extraordinary circumstances were versus extraordinary case. And
right.
Could you explain that a little bit more?
I think there's sort of 3 different things going on here. There's the extraordinary or unusual circumstances, which I think is the phrase that this court used in Freeman. There's also, I think in McCamus, used the phrase extraordinary or unusual case. And here the judge finds this was an ordinary capital case. And so
the judge should know that any case that you're involved in is never an ordinary capital case.
Well, the other aspect of this, which is kind of unusual in these circumstances, is that in Duval County, in Jacksonville, for some reason, the Chief Judge, Moran, is the one that addresses the motions for reimbursement. And so most places, the judge who's actually presiding at an evidentiary hearing is the judge that's going to be passing on this. And I don't know why that's happened in Duval County, but that is one of the circumstances.
Certainly, it makes practical sense for the economics of who's responsible for administering and dealing with the place where the money's going to come from. I mean, it seems to me that's the practical answer, is that's how you keep your finger and your thumb on the cost rather than doing it on the basis of the case.
Well, and I think part of it is there has been some confusion, and I've talked to counsel for the department about this, between JAC cases and Department of Financial Services cases. And so we have gone out of our way in our pleadings to try to make sure that the judges realize we're talking about a Department of Financial Services case, not a JAC case. And so it's possible that a rule or a way of proceeding is developed because of JAC that doesn't necessarily apply with DFS cases.
And that may be what happened. And also, I know there were, because this is the Northern District, there were a lot of circumstances where attorneys were appointed after the dismemberment of the Northern District.
And this is one of those cases. This was a case that had been CCRC North.
Which brings up the question in my mind. Is it correct that there had been a previous 3.850 motion in this case?
Yes, there was a previous.
So represented by the CCRC North.
That's correct.
And they had already gone through an investigation and investigative costs and all this on an original 3.850 motion.
That is correct.
And then once the 3.850 motion is filed and determined, the CCRC people remain on the case for whatever may come next, correct?
Yes.
But in this case, because they dissolved the North, you were appointed.
Yes.
And so then you started a whole new 3.850 investigation.
Well, just to sort of, be specific, what happened is there was a Ring 3850, a successive 3850 filed under Ring that was pending before this court when CCRC North closed.
What kind of a pending 3.851 motion in the trial court?
It was pending in this court. It was pending in this court on Ring v. Arizona. So it was pretty much a legal issue. It was pending in this court. That was going on when I got appointed. And so then my concern is, while that's going on, I need to be concerned about preparing a federal habeas and investigating. And so I have to start, because I don't have the investigator who's been on the case before, and it's in that context that I hire Mr. Ashton to be the investigator in this case.
Now, you don't, you could not use the investigator that had done the previous investigation?
Where I I've inherited other cases in these circumstances, and where I could, I have done that. In this instance, the investigators who had been on this case with CCRC North left the business, so they weren't available. And so Mr. Ashton was, in fact, an investigator who had worked at CCRC North. I was familiar with his work. He had not been on this case. But because of my familiarity with him, I thought that would be the most economical way to go, is to go with somebody in the Tallahassee area, the northern part of the state, to assist me on this case.
I have two questions about this whole fee. Well, one's on the whole fee schedule. The fee schedule that for investigative expenses it can't exceed $15,000. That fee schedule's been in effect since 1998.
Yes, Your Honor.
So the legislature has nothing in there to build in some type of that between 1990 for 14 years that maybe the cost might go up?
There's been no adjustment in terms of the caps. The caps are the same as they were when they were originally adopted.
All right. And the second question I have really goes to a statutory interpretation question. The statute has for miscellaneous expenses is that it's $15,000 except if the trial court finds that extraordinary circumstances exist, the attorney is entitled to payment in excess of $15,000. But it doesn't have that for any other provision in the statute. And we've never, it wasn't until I looked at this case that I saw that extraordinary circumstances was in there, but it wasn't in there for investigative expenses, and it wasn't even in there for any of the attorney payments. But somehow with DFS and over the years, there seems to be an understanding that the extraordinary circumstances language is engrafted in all of the provisions of the statute. Did you notice that?
I had not specifically, because my reading of Freeman, this court's decision in Freeman was that this court basically took Mackison, or however you say it, and applied it in this context, and that there was some indication in Freeman that it appeared that was the legislative intent. I think there's some legislative history.
Well, there was legislative history, but normally when we do a statutory analysis, we say, well, if the legislature uses one term in one provision, doesn't use it in the other provision, the intent would be to only have that apply. But I know this has been litigated with the idea that if a judge finds extraordinary circumstances, that it would be then enough to exceed the cap. But that was one of the reasons I asked you in this case why we didn't just go to miscellaneous expenses.
It frankly hadn't occurred to me. I mean, one of the points that I do make in the brief, had I been aware of this problem, I could have done some of the investigative work and billed $100 an hour for it. And so it seemed to me that it's just an unwise decision.
When you say if you've been aware of the problem, you're aware of the statute, aren't you?
Well, I mean...
And you're aware of the cap in the statute.
I was. I did not realize we were going over the cap. And part of the problem...
Well, people who have budgets and are subject to financial limitations, it's like we have a budget. We're careful about not going over it. And we take extraordinary measures to make sure we don't, because there are big problems if we do. We can't go over it. Things happen. So to just say there's a budget that's established in the statute and you're not aware of the cost, I mean, that doesn't seem like a really satisfactory answer.
Well, I'm sorry, that's simply the truth. The evidentiary hearing was ordered in January of 2011. I asked for more time. I was given 60 days. My focus was on doing the evidentiary hearing. The evidentiary hearing was in front of a different judge than Judge Moran. Judge Moran's order is that I'm supposed to go to Judge Moran when Judge Southwood orders an evidentiary hearing, advise Judge Moran, and get his permission before I exceed the cap. And so I'll be dealing with two different judges. In this case, at the evidentiary hearing, the state was contending when Mr. Ashton was on the stand, he hadn't done enough. And so we're caught in this cross situation where if we're concerned about Mr. Moore, who's maintaining his innocence, and we're trying to present the case, we're supposed to stop and say, oh, well, Mr. Moore, we need to pause here and come over here and think about this fee arrangement. I mean, I was under the gun. I had 60 days to get ready for this evidentiary hearing. The excess of the cap all occurs the week of the evidentiary hearing, when you figure out the number of hours. And he's also a witness at the evidentiary hearing.
One of the things I'm worried about in the CCR, the whole structure, the way we've done things, we have a public defender's office who have in-house investigators. We have in-house psychologists. They have all these things. And yet CCR gets these cases, and you don't have access to those things. Well, you have to go get them.
To clarify, CCRC South and CCRC Middle do have that.
Right.
And so CCRC North had that. So what happens here is that Mr. Moore and other individuals who were with CCRC North that get tossed out to the registry, suddenly the whole process changed. And I think it creates perhaps an equal protection problem. Mr. Moore.
I'm thinking where I come from, down south.
Okay.
Where you get appointed to represent folks in these cases, then you got to go beg for money to hire an investigator. You got to go beg for money to hire a psychologist. Meanwhile, the state has access to the world. And it concerns me that we're dealing with this finite budgets, and that you have to concern yourself with the quality of representation you have to afford these folks who the state wants to execute based on a budget. And you have to tell an investigator who may be telling you, I can do more, I can find out more, but I can't. And you're telling him you can't go there because we're going to exceed the budget. And it concerns me, the whole system that's based on that basis.
Well, and along those lines, CCRC South, with their cases in this situation, they wouldn't have to worry about it because they don't have that same budgetary constraint, or CCRC Middle. And so Mr. Moore only has that problem as to his case because his case was removed from CCRC North and placed on the registry.
What has happened as a practical matter? The legislature, was it last term, abolished the Capital Commission that was really looking over the registry? So what exists now?
Nothing. I mean, really.
So you're really on your own. I mean, now, you are capable of being on your own, but for other attorneys, there's not even that umbrella to sort of make sure there's some quality control in who is representing a particular defendant and the quality of that defense.
There really is no oversight. I mean, to some extent, I know that some registry attorneys have tried to form a bit of a network to check with each other online for ideas, et cetera, but there is no sort of resource center or no one other than calling up CCRC South or CCRC Middle or another registry attorney. There's no sort of...
Do you get the feeling here, because we're only talking, these things are televised, you exceeded this cap by $1,844.
That's correct.
Presumably, if this isn't allowed, this comes out of your pocket?
Yes.
Because this is an actual expense. You could give up you could give free time, but I'm assuming Mr. Ashton needs to be paid.
Yes, Your Honor.
And what was his hourly rate?
$40 an hour.
That's what's set by the...
It's set by the statute, yes.
Okay. So, did you...
But you're saying you're personally liable for that?
The way that it's set up is that, in essence, makes me personally liable for it because I have to ask, I submit the billing to the Department of Financial Services. They review it. Then I do a motion. I do a motion to the court, and the money is paid to me, and then I pay it out to the individuals. I suppose I could say, well, Mr. Ashton, too bad, but I'm not going to do that because,
So Mr. Ashton's contract, if he has one, is with you?
Yes.
Right, because you have to, that's why the miscellaneous expenses, whatever it is. So it seemed to me that what the chief judge was upset with is that you didn't come to him first. That was sort of because there's no other, there was really no evidence, there was no hearing on this.
Ms. Jobe with the Department of Financial Services and I do hearings on this regularly, and one of the things that has come up is we hate to spend money to save money, and so traveling across the state for hearings like this is expensive, and so frequently she will appear by phone or I'll appear by phone, and in this instance, because she's in Tallahassee, I'm in Fort Lauderdale, we both appeared by phone, and we really had not, from my point of view, I hadn't anticipated the problem. I'll let her speak for herself. But I don't think that we really anticipated that. And I just wanted, I made the transcript from the evidentiary hearing part of it. And so that's how we were proceeding.
Mr. McClain, you're well into your rebuttal time. You can continue or you can save the rest of your time.
I'll save the rest of my time. Thank you.
May it please the Court, I'm Richard Donlan from the Department of Financial Services, representing CFO Jeff Atwater today. We are in an unaccustomed role because ordinarily we simply pay the bills. And one thing that I have to stress to you, and it was just what I stressed to this Court in 2006 in the Freeman case, and that is that the CFO has absolutely no authority whatsoever to pay beyond the limits that the statute allows. And there's a reference, Justice
and that's what you
Kennedy.
need the judge's finding.
Yes. So, I mean, basically, that is, the judge plays the critical role in determining whether there is a constitutional violation associated with not paying more money for something or other. And I know
it's sort of the constitutional violations creep up. First of all, as we know, in post-conviction, there isn't a constitutional right to effective assistance of counsel. But as a matter of what the state has done in making sure there is counsel for all death penalty, death cases where the death penalty is imposed, is they want a quality, a minimum quality to be there. And there is a great concern here that the cap hasn't been raised for 14 years. We don't have the commission overseeing the registry attorneys. We still have the Northern District that hasn't been reconstituted. So your only interest is to make sure that you have a judge's order that says these were extraordinary circumstances, and then you're authorized to pay it. Is that correct?
Yes, because this Court has concluded that if a judge concludes that it would offend the Constitution, and of course the Makemson case talks in terms of being confiscatory of counsel's time and effort. Now here we're really not talking about counsel's time and effort. We're talking about an employee of the counsel.
Yeah, it's sort of worse in a way. I mean, to me, it's worse for this, that an attorney can give of his or her time and say, listen, it's confiscatory, but I care about the, people having the right to, if they claim innocence, to be able to assert that. But investigators aren't in that same situation. They're not officers of the court that can just say, we're going to volunteer our time.
Yes. Well, I also represented to the Court in the Freeman case that the Department considers the attorney to be the gatekeeper. If there is a budget, and I certainly agree with your comment, Mr. Chief Justice, that the state offers a budget for investigative services. And it is incumbent upon that attorney to budget that $15,000. In this case, the record shows that over $9,000 of that original sum of $15,000 was spent shortly after Mr. McClain was appointed. By 2006,
Let me ask
all of
you
that money...
about,
Excuse me, Madam Justice?
About investigators generally.
Yes.
You see a lot of these. How often do you get requests for more than the $15,000?
I would have to defer to Ms. Job. What would you say, Ms. Job?
And how often do you actually pay it? More than the $15,000? If you don't have that information, that's fine. But it's of interest to me. We haven't seen this kind of issue, at least not an investigative fee issue before. And so it's of interest as to how often counsel feels it's necessary to go beyond the cap. 75% of the time when it's requested.
And, Your Honor, there never has been a case that has been litigated on this issue. So this is, in fact, the first time it's ever come up.
Let me go back to where you started on the question that your department does not have the authority to exceed the cap.
That's correct.
You have to go to a judge, and I take it the judge has to make some type of factual findings to exceed the cap. Now, in Makinson, we came out with this as applied type of test.
Yes.
And wherein the trial judge, I assume, has to make factual findings about the efforts made by counsel, the extraordinary efforts made by counsel that would justify exceeding the $15,000 limit.
Yes.
Now, here's my concern. My concern is that we have one judge who is not involved at all in the litigation of the case, who doesn't know the efforts, how many times his lawyers are in court every day, doesn't know really much about the case except what, probably reading the motion, making these one-fits-all type decisions, it seems to me. Should it not have been the judge who had been presiding over the case all along, who makes these decisions as to whether or not the cap should be? Isn't that the proper person to really have the knowledge about the case to apply this as-applied test that we have in Makinson?
In some cases, I would agree with that, Your Honor, and in some cases, I don't think it's absolutely necessary.
Well, in this particular case, I mean, we ordered a hearing in 5 years hence in the case. Mr. McLean, you heard him. He had to gear up real quickly. He had to hire investigators real quickly. It seems to me like he's doing the best he can to basically comply with our order. And now you have a judge saying, I'm not going to give you $1,800 because you went too far. And a judge who did not even preside over the case. And that concerns me.
Well, Your Honor, I will say that the transcript of Mr. McLean's March 22nd, 2011 hearing was supplied to the judge. Now, Mr. McLean has said that it's uncontested and uncontroverted evidence, but in fact, the evidence was highly controverted by the state at the time.
I was a trial judge, and it's one thing to read a cold transcript, and it's another thing to have been there throughout the entire case and watching the litigators, and you get a feel for these cases, and I just don't know that you get the same feel from reading a transcript of a hearing. It concerns me that we have one judge doing all these things without having any involvement in the case.
Well, Your Honor, there's a wrinkle in this case as well, because the motion for reimbursement was filed before the trial judge who presided over the 3.850 hearing actually issued his order on that. And so it certainly would appear that by staging it through in that fashion, you would probably prevent the judge who was hearing the 3.850 motion from actually making a ruling that would, pretermit his ability to rule on the substantive issue.
Well, this is, we want to make sure that the law on this stays stable. And so we were asking questions about how much gets paid. Do you know across the state whether it is generally and maybe Mr. McLean could answer this, but is it generally the judge who hears the case that's authorizing the additional payment?
I think it depends a lot on the sophistication and the size of the circuit judge contingent. I know that in Leon County, Judge Hankinson hears all of the reimbursement cases associated with the registry. And he's in not necessarily cases in which he is the trial judge.
Now, we've talking around the issue of whether there are extraordinary circumstances.
Yes.
It seems to me that we have a situation here where the successive motion, which was alleging that really this was a setup by the younger co-defendants or other people, were that they really wanted to pin it on Mr. Moore, and that the investigator, Mr. Ashton, went out and in 2005 or 2006 found these witnesses, investigated it, and apparently
actually had a bill of, $9,000, I think was what was said. For whatever reason, but knowing the kinds of things that can happen over in the Fourth Circuit of years going by before a evidentiary hearing is set, nothing gets set for 5 years. Well, from the court's point of view, this is really an unacceptable situation. But it happened. Hopefully it doesn't happen going forward. Now Mr. McLean has to scramble, and it would be really an abdication of his responsibility if he didn't have his investigator go back and contact the witnesses. I mean, we would, if he were to put on witnesses that hadn't been talked to for 5 years and put them on for an evidentiary hearing, we would be saying, well, that's not what we expect of a lawyer. So he did what was expected, which was to have his investigator go back. And now the investigator, because he's had to do something twice through no fault of Mr. McLean's, but because of the court system, he's having to now go $1,800 over the cap. And we're up here before the Supreme Court of Florida trying to decide whether Mr. Ashton should get this or whether Mr. McLean has to eat it. From your point of view, because none of us, again, as you said, we haven't been up here in a while on this, going forward, what would be the way to handle this into the future? What does the department suggest so that we don't have, it depend on whether it's down in Palm Beach County and Justice LaBarga presides, or it's up in Duval or over here? What can we do to sort of stabilize this situation?
Well, the first thing, Your Honor, you would have to find some way to determine that there would be a constitutional, unconstitutional, as applied reading of the investigative fees.
Well, why couldn't we do it based on? Can't you just take this being miscellaneous fees, and which require extraordinary circumstances, and just pay it out of that?
Well, and that's a good question, because if you look specifically at what was billed for the investigator's time, there was a lot of stuff that probably could have been done by someone other than an investigator, which could have been considered to be miscellaneous fees.
But it could have been, but Mr. McLean says he could have gone and talked to these witnesses, and now you're up to $100 an hour. Do we want to encourage him to, like other attorneys might do, to say, I'll do it because I want to get this additional money? Do we want to encourage attorneys to spend $100 an hour when $40 an hour could suffice? I don't think so.
It might be possible if the attorneys talk to the witnesses, they might have a better idea that the witness's testimony was not particularly impressive, and they might want to consider.
Well, now you're making a judgment on this, but what you're really saying is the department would have been fine in paying more money if it came out of another pocket of the money. Is that correct? That hadn't been exhausted.
I am not saying that. I am saying that traditionally, this has been a matter in which the lawyers were permitted to decide how they wanted to do it, as long as it came within the budget allowed by law. Our role has been circumscribed by the fact that if we got into every case and fought over the reasonableness of fees, of course, the counsel for the death sentence inmates would be saying that we are joining with the prosecutors to, interfere with the rights of the inmate, and so we cannot do that. We are not in a position to have gone to the hearing here and have said, Judge, we've looked at these fees and we have some questions about them, and we want to, get and start getting into an adversarial relationship with counsel. So in our delicate way of doing that, we simply allow them the ability to designate where their expenses are coming from.
Okay, so if Mr. McLean resubmitted the $1,800 under miscellaneous expenses for the investigator's time at trial, that would, at the hearing, it could be paid under that?
If the court were to authorize us to do that, Your Honor, that would be the issue.
Well, does it fall within in other words, just because he's an investigator, if he's testifying, what are miscellaneous expenses?
It certainly would appear to be not investigative services to be serving as a testifying witness.
But isn't there a danger for the lawyer real danger in putting expenses in wrong categories, because that's the one area, if they do fraudulent billing, that they're gone, they're toast.
There's no question about that.
So that I think is really trying to, for Mr. McClain to try to put it somewhere else is I respect that a lawyer will put it where it is and not create that kind of issue with regard to these things, because, I mean, if we start getting into that, we're going to have nobody left to do anything.
Yes. And that's why I replied very carefully to Justice Perry.
Well, and the statute has these different categories.
Yes.
So you can't just say, oh, well, we've run out of our money for the investigative category, so we'll put our investigators' expenses under this other category. I mean, that would be...
Traditionally, Your Honor, we have not done it that way.
I know.
Well, and the court shouldn't let them do that either.
That's right.
Well, the statute says miscellaneous expenses such as the cost of preparing expenses, compensating expert witnesses. It's not an exclusive list. I mean, so Mr. McClain didn't make this argument. It was just me looking to see that this seemed like this $1,800 should be paid. It is really unfortunate. Mr. McClain has to be up here. You have to be here for an oral argument over something where we're just trying to make sure that Mr. Moore gets proper representation and that he is not the one that is prejudiced by whatever we're arguing about here.
I think, not to beat a dead horse, but my instincts tell me that had the judge who presided over this case heard this motion, we wouldn't be here today.
That is entirely possible.
Probable.
If there are no further questions, I'll be happy to sit down. Thank you very much.
What was the reason for the 5-year delay?
In the course of those 5 years, well, one of the things that had happened is when CCRC North closed, the files, Mr. Moore's files, were sent to another registry attorney, Chris Anderson, who had briefly been appointed, and then I was appointed. By the time they got to me, stuff was missing. And so I asked to have, and the stuff had never gone to the repository because it was before the repository.
Okay, so it wasn't so then it wasn't the court that was it you preparing for 5 years?
Well, part of it was getting access to that. Then there was also Ms. Corey was the assistant state attorney on the case, and she left the office. So there's just sort of a series of things that happened.
So it was not the judge. Then it wasn't the judge that delayed the evidentiary hearing.
I wouldn't say that. We had a number of hearings, and just so the court knows, the record in Thomas Moore's appeal has just been filed with this court like about 3 weeks ago. So it is before the court, and so all of that information would be in that record. But there were a series of events that happened. And also, Judge Southwood is a senior judge, and I don't mean any disrespect, but in terms of he's not at the courthouse all the time as well. So when he tended to schedule his capital cases at the same time. So there was another capital case that was going along as well.
Mr. McClain, I think you are a great lawyer, and I enjoy your arguments. But I really don't want to hear your $1,800 fee cases ongoing, nor your defensive colleagues. So a de novo standard of review seems to me to invite just a lot of these kind of cases going on an ongoing basis. Why shouldn't we do something other than a de novo standard of review?
And I'm not really disagreeing with that. And first of all, for me, I don't intend to be here a lot with these kind of cases. It seemed to me that there's an underlying important principle here where there's a whole bunch of things intersecting. And what happened here is, it seems to me, when the judge says this is an ordinary capital case, I don't think that's the test, because I don't think there is such a thing as an ordinary capital case. My reading of what this court said in Freeman is whether or not there's extraordinary or unusual circumstances.
So what is it you want us to do? You want us to say that it is, or send it to the trial judge to make some findings?
Well, first of all, as in this instance, again, there was no evidentiary hearing. It was the transcript from the proceeding. To the extent that the opposing counsel is saying it was contested, what was contested at the hearing was that Mr. Ashton hadn't done enough, not that he had done too much. What I'm asking is, well, I think on the record here, since you have a cold transcript, which is the same thing that Judge Moore had, this court can say what the proper standard is, and go ahead and apply it. I don't think it has to be remanded. But I think that this court, in addressing this issue, needs to give guidance and standards, because I think it needs to be consistent statewide. And right now, I mean, this is the only case I've had where it's not been found extraordinary or unusual to go over a cap. Also, one of the problems in this case...
Is it usually done by the trial judge?
It's usually done by the trial judge. My experience is Duval County and Pinellas County. I haven't actually had a case in Leon County where I've appeared, but those two counties are two counties that I know of. Everywhere else, it's the judge who presides at the evidentiary hearing or at the case management who's considering it. And the only other final point I'd make is that when an evidentiary hearing is ordered, the statute provides $20,000 for attorney's fees to prepare the motion, $20,000 for the evidentiary hearing. And so one of the problems with this structure is it's $15,000 flat for the life of the case for the investigative fees, which doesn't take into account that an evidentiary hearing is going to require additional work. I thank the court for its time, and I ask that this court reverse the order. Thank you.
We thank you both for your argument. The court will now stand in recess for 10 minutes.
All rise. Supreme Court of Florida is now in session. Please be seated.
We now come to the third and final case on today's docket, Intervest Construction of Jacks Inc. versus General Fidelity Insurance Company.
Good morning. My name is Braxton Gillum. I'm here on behalf of Appellant Intervest Construction of Jacks Inc. The 11th Circuit poses two issues for the court's consideration. One, can ICI, under this policy, use the custom cutting payment to meet its self-insured retention obligation? And if it can, is there anything in a limited fund scenario about the transfer of rights provision in this policy that grants priority to ICI or General Fidelity, again in a limited fund scenario? I suggest to the court that when evaluating
the first question, whether the policy allows ICI to use the custom cutting payment to meet its SIR, the court really has to consider whether or not there's anything in the policy that prevents ICI from using this money to meet its self-insured retention. The policy says that ICI, actually it says the self-insured retention must be met by you, referring to ICI. In other place it says the self-insured retention must be paid by the insured, again referring to ICI. It is because of that language that ICI spent time in its brief explaining that the custom cutting payment belonged to it. At the time the custom cutting payment was agreed to be made, and ultimately when it was made, the only party who had a claim to that money was ICI.
Well, what about, let me ask you about the transfer of rights, because I understand that we've got these two different questions, but it seems like to me, at least arguably, they're really, you've got to be merged into one question, because you've got to look at all of these provisions together. And to focus on one aspect of it, just the SIR, without also looking at the transfer of rights, is to not look at the policy as a whole. But when in the transfer of rights provision, what does the word transfer mean?
Well, Judge, I think what it effectively is a contractual subrogation obligation.
No, transfer means subrogate?
Well, it means my client has to give, and or they're owed my client's right to recover monies they pay on my client's behalf. But only at the time, and at such time as they've made a payment on my client's behalf.
Well, they paid $300,000, haven't they?
They pay $300,000 after the resolution of my client's claim of custom cutting.
Well, but as part of the resolution of the settlement with the plaintiff in the underlying case, they paid $300,000. Now they want it back, right?
That's the issue, Judge.
And you paid $300,000, and you want that back, and that's why we're here. This little detour from the federal court. But I'm still go back to my question about transfer, because in the transfer of rights provision, it seems like to me that is talking about the rights that they that would encompass the rights they had under the indemnification provision, or the right your client had under the indemnification provision with the subcontractor, and your client has transferred that right to the insurer. And it seems like transfer means transfer. The right you had to that has been given over to them. That's what transfer means. If I transfer something, I've got it. I give it to the transferee. And they paid $300,000. They had a right. They've got your right to the indemnification. And so why aren't they entitled to it on that basis?
Because, Judge, nothing in the policy says we transfer all of our rights under the indemnification provision of them. It
says without limitation that you transfer your rights.
It says we transfer such rights as in the money they pay. In other words, if they pay money, we transfer the right to them to go and collect that money they paid. That's all.
Okay. If the insured has rights to recover all or part of any payment we have made under this coverage part, those rights are transferred to us.
I agree, Judge.
Well, I mean, I'm sorry. You looked triumphant when I read it, but I'm missing something. Explain to me how that establishes your point, because I'll explain that further.
Judge, in the words you read, it said we transfer the rights to them to collect the monies they paid. Only the monies they paid. We didn't transfer our entire right, nor does it request us to transfer our entire right to recover under our contract of indemnity. There's more pieces to recover against the third party, in this case custom cutting, than just the $300,000 that was paid by General Fidelity.
Well, let me ask you this. If the payment from North Point to ICI have been $160,000, I mean $1,600,000, would your general insurance company be entitled to that $600,000?
Absolutely. I mean, I think the issue in this case, and really was a secondary question, I appreciate the court's comment that they seem to be merged, but this issue about who's got priority under the transfer rights provision only comes up in a limited fund scenario, this made whole, truly made whole context. If there was $1.6 million of coverage available to custom cutting and or custom cutting had $1.6 million in their bank account, we wouldn't be here because there'd be plenty of money to repay both my client for what it was out and what General Fidelity was out. That's not the case. There's only $1 million. They were insolvent. There was only $1 million available to them through insurance to pay the claim, and so we had a limited fund. So who gets the money? That's the question. And the issue really turns on again. I mean, we rely on Bordeaux. We recognize it's a Washington Supreme Court state case, but that case relies on courts from this state to reach the opinion that when you've got a policy that's silent, as the 11th Circuit acknowledged, as we acknowledged in our brief, and as on page 33 of the answer brief, the General Fidelity folks acknowledged, when the transfer of rights provision is silent, you've got to go to the default provisions. And the default provisions under Florida law, as under Washington law, is the made whole doctrine. You've got short funds.
But how does that made whole doctrine make any sense at all in the context of a policy that has an SRI provision in it? I mean, because there the notion is, if you've got a self-insured retention, the notion is that the insured is self-insuring up to the amount of the retention. Isn't that correct? And how are they going to be made? I don't understand how they're to be made whole at the expense of the insurer when they have not satisfied their self-insurance obligation.
Judge, your question falls in line with the comments of General Fidelity in their brief when they say things like, generally speaking...
Very observant of you.
Generally speaking, they say self-insured retention looks a lot like primary levels of insurance. What they're really saying there is under California law, self-insured retention is a primary layer of insurance. It's not the case under Washington law where the Bordeaux case was decided. And frankly, again, Bordeaux relies on Florida cases, the Zinke case and the Young case, or the proposition that...
But they're cases that really don't involve the same issue here. And how you characterize it, whether it's self-insurance is insurance for some purposes or not for other purposes, we've got to look at it in the context of this case and the authorities that bear on this kind of issue. And you don't really have anything like that from Florida, do you?
I don't think there's any case like that in Florida. I agree with you, Judge. But I'll tell you what I do think we have here before this court is a contract that speaks specifically to the issue. I mean, another provision...
I think opposing counsel agrees with you about that, and probably everybody will agree with you about that. We may disagree about what it says, but...
Well, what I mean by that, Judge, is if you take a look at the other insurance provision of this policy, which everybody agrees, including General Fidelity on page 19 of their brief, doesn't apply because my client doesn't have any other insurance. They're not an additional insured under any policy. You look at that provision, however, and it says specifically, General Fidelity's policy in this case is primary, except and only when the insured, my client, has other insurance available to it. In that case, the General Fidelity policy is excess. So they say in their policy, this particular policy that governs here. So I say to you, even if you go to California, and we rely on the California cases to talk about what SIRs are, and when you're talking about primary level of insurance and what that is.
The provision you're talking about now, where is that?
It's in the other insurance provision of the policy, Judge. It's page 11 of 15 in the policy of insurance. I'm not sure if you have it in front of you. I'd read it to you if you...
Sure.
It says other insurance. If other valid and collectible insurance is available to the insured for a loss we cover under coverages A or B of this coverage part, our obligations are limited as follows. A, primary insurance. This insurance is primary except when B applies. And B talks about when there's other insurance available to my client.
Are you a third-party beneficiary of North Point insurance policy?
No, Judge.
You're not?
We're not an additional insured under that policy.
He didn't say additional insured. He said third-party beneficiary. A claim.
Not in my brief, Judge, but I think I'm sorry. Not in my brief, Judge, but I think Florida law talks about, when you're talking about third-party beneficiary status, you've got to be intended. And here, I think that's the point of
his question is a claimant under the policy a third-party beneficiary of that policy? I think that's
exactly right.
That's where he's asking.
I don't think that's what Florida law says, Judge. Okay. My client's a claimant against custom cutting pursuant to a contractual indemnification provision. We made a claim on them. They made a claim on their insurance.
Well, if you were a third-party beneficiary, and I appreciate your candor that you're not, but if you were, I think that would make a big difference.
I'm not sure it wouldn't hurt me, Judge. I mean, clearly if we're an additional insured under this provision of other insurance, that they'd have a good argument, they'd be in general fidelity, that they were excess over that coverage. But we're not. The only reason we were paid the money, what I call the custom cutting payment throughout our briefs and also here in conversation with you today, is because we had a contract that says you will indemnify us from your negligence.
Exactly. So if you had in the subcontract or in some way required a third-party beneficiary policy in some way, I think you'd be in a different posture. But it seems to me you've got some subrogation rights, so does the insurance company. You're in an equal posture as to this third-party pot of money coming in the door. So I don't understand why your client shouldn't be on the hook for the self-retention, for the $1 million.
Well, I mean, Judge, again, in the context of when you've got a limited fund, who gets the money in a limited fund? And when the contract doesn't say they get the money in a limited fund, the insured gets it.
You've got $1.6 million total damage, right, or yes, total claim. There's been $1 million supplied, so you're left with $600,000 that has not been supplied or paid by somebody else. So then, how does that get distributed? Your client has $1 million self-retention, and then the insurance company comes in behind that. I don't see where there's anything in contract or any other policy that alters that.
The $1 million that was paid was our money, Judge. We paid the $1 million.
Let me ask you in this way, because over here.
Sorry.
Yeah. I'm sorry. You built this house. Your company built the house, and you contracted with this custom cutting for the staircase. Okay. At that time, when you were building the house, did you have the insurance with the insurer here?
No, Judge.
So the agreement, how you decided to protect yourself if you were sued by the homeowner, was an agreement between you and Custom Cutting?
Yes, irrespective and prior to our relationship with General Fidelity.
Okay. So then you're looking for insurance in case you get sued, and you enter into negotiations with General Fidelity to look at what kind of policy your company wants to have, a general liability policy. Correct?
Yes, Judge.
And at that time, I guess, we look at what the contract says, but from the point of view of the insurance company and what kind of premium they're going to charge, they want to know, are they on the hook for the first $1 million or not, correct? That's what the self-insured retention is.
Yes, Judge.
Okay,
but in part, I would say in part.
A friendly question here. I just want to, because did they, at that point, ask, would the premium have changed upward or downward depending on how else you had protected yourself? And I think this is an important thing about the benefit of the bargain. In other words, did it make a difference in the premium that you're charged, whether you had already had indemnification agreement and insurance with your subcontractor as to what the type of insurance contract you would get and what kind of premium would pay, or is that in the record at all?
I would say absolutely. I don't think it's in the record per se, but I would say absolutely because there is specific provision in the policy where they prevent us from using certain pots of money to meet our SIR. And there's no provision in the policy that says you can't use indemnification from prior subs to meet your SIR.
I mean, and that was sort of where, to me, this is different from the California cases because the insurance company could have written it to say, include specifically any money you might get from any policies that you already had benefiting you.
Yes, exactly how they did.
But I'm still troubled. Let's go. So I'm less troubled by that issue. I think you get this, the self-retention, but the transfer of rights provision. Are you saying that if what had happened was because I think this was great for the plaintiff that everybody agreed that the plaintiff would get the 1.6 and then you'd worry about where it's going to be paid. So that's I think that you all minimized any kind of problems, for the plaintiff. But are you saying that if the money had not been paid out first, say you decided to pay the $1 million and then sought reimbursement from the custom cutting, that it would have been different as to whether the insurance company would have gotten that money because of the indemnification provision?
No, the results would have been the same. There's
so
nothing.
It wasn't a question of who paid first.
No. I mean, we've argued this provision, transfer of rights provision, does not apply because of the timing of the payment. But irrespective of that, it doesn't matter when payment was made. It doesn't say who gets priority.
Okay, and if there was $2 million from custom cutting, there wouldn't be a case here.
Correct.
Okay.
Reserve our time, Judge. Thank you.
May it please the Court. My name is Louis Schulman, and I'm here representing General Fidelity Insurance Company.
If there was $2 million, what would have, from custom cutting, and everybody sold for 1.6, would you still have insisted that they pay $1 million out of their pocket first, or would you have been content to have the $1 million being paid by the custom cutting insurance company?
Well, in the context of the settlement, Your Honor, if custom cutting was at the table.
No, but I'm asking because I'm trying to sort of see what we're playing with here. Would you still have insisted that they pay $1 million?
Theoretically, yes, but they would have been reimbursed $1 million. So it all happened simultaneously. So I don't really think timing is an issue in the case. Here we were all at the table together. They, in fact, theoretically at least, did pay $1 million and then were reimbursed the $1 million from custom cutting. And whether you say that they have to physically write a check or could they take the money from custom cutting, I don't think that makes any difference.
Could you write a policy where you specifically identified indemnification as a source that would be not part of the self-retain limit? Do you understand what I'm saying?
Yes, Your Honor. Oh, certainly. I mean,
and there are policies that actually are very explicit on that.
Yes, they're more explicit in some of the California cases about using money from your own funds and from your own account. That is true.
I guess I go back to this thing that if it can be more explicit, and we're really dealing with here, it's not this is a sophisticated insurer, sophisticated contractor, then if that was what was intended, why wouldn't you use a more explicit language? It's sort of where in trying to understand, why do you get the benefit of their being smart about getting a indemnification on their for their subcontractor?
Well, the answer to that, Your Honor, is I guess that policies could always be written in retrospect better than they are.
These were some of the California cases those were 20 years, that was a long time ago, and they were explicit on that, so there was no question about it.
Well, I think we've addressed that in another way in the policy, Your Honor, and we've addressed that in the transfer provision because...
Okay, so now you're going to where Justice Kennedy was, which is you're saying you can't look at these as two separate questions. You may lose on the... Well, you may not concede that. You may lose on the first point, but you think you win because of the transfer of rights provision.
That's not exactly our argument. Our argument is you don't ever... The second part of that question answers the first part. In other words, if in fact, as the transfer of rights provision says, once there is a loss, you must do everything in your power to protect our right to indemnity. At that point, the right is transferred as soon as there is a loss. And therefore, they have no right in the first instance to apply the indemnity.
What does that say in that provision?
That's in the transfer of rights.
What language in that provision says that?
I can't. It's in paragraph 8 under the commercial liability conditions in the general liability main form, and it says the insured must not do anything after the loss to interfere with these rights, referring back to the phrase that says, if the insured has rights to recover all or part of any payment we have made, these rights are transferred to us. And then it says the insured must not do anything after the loss to interfere with these rights. Well, in effect, if they've taken the indemnity money, as soon as they've taken the indemnity money, they've interfered with our rights. I mean, essentially, they've taken the money. We have no indemnity rights left, even though they've been transferred to us under the policy. The fact that they even use the indemnity payment to satisfy the SIR has,
so
in fact...
You still are maintaining that, assuming there was just $100,000, $1 million that was given by North Point, that ICI could not use that $1 million to satisfy their SIR.
Absolutely, and that's for two reasons. A, because of the definition of you and your money, which admittedly is not as strong as the California cases, but B, also because the right to recover any indemnity payment has been transferred to us prior to them even getting their hands on it, and because they're not allowed to interfere with our rights to the indemnity payment, therefore they obviously can't use it to satisfy the SIR. The thing that is interesting about all these other cases that are talked about in the briefs is that they relate to different factual scenarios dealing with the specific provisions of the policy. For example, in the Vons case, which is the one California case which is against us, they talk about the other insurance provision, and they talk about the other insurance provision in the context of an SIR, which frankly I don't think it has the you language in it, but also it talks about the other terms of the policy taking precedence over the SIR. Our provision actually says the opposite of that. Our provision in our policy says to the extent that there is any conflict in the provisions between the SIR and the principal policy, the SIR controls. Here, the interesting thing about the argument...
Let me ask this question.
Sure.
Let's follow this through on a little different route than a settlement. If the contractor had been involved in litigation, plaintiff sues for injuries, and there is, in the nature of a third-party complaint, the indemnification, but it's severed, and this case goes to trial, and there's a judgment for 1.6, and the construction company goes out and borrows $1 million and pays the $1 million, you would have to pay the $600,000.
Yes, Your Honor.
Correct?
Yes.
So that answers the SIR issue. Then comes the next one when the action is filed with regard to the indemnification.
Exactly.
So then you claim that this clause, the transfer of rights, operates in that scenario to allow you to get back the $600,000 before the contractor can recover the $1 million of it. Let's say they had $2 million of coverage.
Yes.
So that's the way that this would operate.
Yes, Your Honor.
Okay. So it seems to me is that we really have two questions here, and that it's dangerous to combine the two because it may not always fit exactly and precisely with indemnification, because under the SIR I could ask the chief to loan me $1 million and to pay for my portion.
Bad chance.
And your argument, he doesn't like me very much.
I don't have it.
But you understand what I'm saying,
yes,
is that there's two provisions here that we have to be very careful about because it will impact future cases. And under just the SIR, your contract doesn't say it has to come out of my pocket. It just says I have to pay it, correct?
Exactly.
Okay.
And frankly, the limitation as to what funds would be deemed the funds of the insured under the scenario where it just uses the word you or the insured, I can't tell you the limit on that. If you borrowed it from somebody, I presume that it
so
could
really
have.
this case is really about the second provision, this indemnification concept, and whether under that clause that you take priority on obtaining the benefit of any monies that are obtained through the indemnification concept, whether it's funded through insurance or not.
Yes, Your Honor. Well, if it were funded through insurance, we'd have to look at the provisions of the other insurance clause. If in fact
that's excess, I understand.
Exactly. If the other
party
that
wouldn't come into play necessarily in the indemnification scenario.
No, it wouldn't necessarily unless they were named as an additional insured under that policy.
Yeah.
Well, what concerns me about this transfer of rights provision is it says if the insured has rights to recover all or part of any payment we have made under this coverage part. But your obligation under this contract really doesn't kick in until $1 million have been paid.
That's correct.
And so it seems to me, with that in mind, that you don't have any payment to be made until after $1 million has been paid. And so that's when your rights kick in. And it seems to me you would then have a right to any money that they are able to or could recover beyond the $1 million. It just seems to me to be a very simple concept, but maybe it isn't. Explain to me why your client would be entitled to part of the $1 million when your obligation doesn't kick in until after the $1 million has been paid.
Well, we're talking about two different $1 million here, I think, Your Honor. We're talking about the $1 million that the insured has to pay and the $1 million.
Well, we've already covered that the $1 million that the insured has to pay can come from any source.
Well, it can't come from indemnity, because our policy specifically that's what when we're talking about the second clause in this policy, which deals with the transfer of rights.
Because your position, that's not their money, that's your money.
That's our money. That's exactly correct. And then
if we accept your reading of that particular policy, but is it really your money? That's the real question.
Well,
in my mind.
It talks about in that provision that the insured may not do anything to interfere with our rights to recover that money.
Yeah,
so,
but again, those provisions, those are standard provisions. That really means that they can't go out and give a general release or something of that nature. The provision is clear that you have subrogation rights. I think that the way the 11th Circuit said it, the provision gives no guidance as to the priority as to who is to recover when the indemnity amount is insufficient to make whole both parties. That's what we're talking about here.
Yes, Your Honor, I agree with that.
So we're talking about not that you don't have subrogation rights, but when there's a limited amount, they can recover their amount before you on insurance that they paid for, not you, to get theirs first before you. And if this is a question of the contract controlling, then tell me about the interpretation of this given by that Washington State case and how that is not consistent with the made whole doctrine that this state has recognized when there's a limited amount of indemnification available. I mean, that's where I thought the two come together, that this state has understood the made whole doctrine and that the insurer gets money after the insured is made whole.
Yes, I agree with you, Your Honor. That is, in fact, the crux of this case. And the reason that this case comes out different is because the allocation of the risk is different. Here, under the terms of the policy, the first $1 million is self-insured by the insured, and they have that initial risk. It's the excess risk that General Fidelity has agreed to take on. In every case involving that type of allocation of risk, the party that has the secondary risk is entitled to reimbursement first. Because
so you're really, maybe you might have said this, but you're really saying that the $600,000, which was the extra, should be paid out of the $1 million. So, and that's why then they'd only have that. If you just look to that, you get that. You don't pay the $1 million, and out of the $600,000, you get to be paid out of the $1 million first before they are.
Exactly, Your Honor. And in fact, I
don't know, but I at least I understand. I'm seeing how that can make that's a certainly a reasonable argument. Now, whether the policy supports that unambiguously is where I have my concern.
Well, Your Honor, let me address that question, because I think that in allocating the risk, in allocating the first $1 million of risk to the insured, which is what this policy does, That in and of itself makes this clear, because once having allocated the first $1 million of risk, and this is the case in all areas of primary and excess insurance, the right to reimbursement goes first to the party who's entitled to it because they've taken on the secondary risk or the excess risk.
And certainly in excess, I mean, I understand that. I understand self-retained limits. The lawsuit here, I mean, we really never got into the fact as to whether it all was the fault of custom or whether the builder was also at fault, so that we're not really, whether everybody by compromising decided we're going to handle it this way. Now, if it was different, which is they have their own liability because they didn't inspect it properly or whatever, other than just vicarious, would that change anything about this case?
Yes. I mean, it definitely would, because, of course, they wouldn't be the indemnity that they are entitled to relates to the negligence of the subcontractor.
Right.
So, in fact, yes, if they were actively negligent, we wouldn't be talking about indemnity. That the whole case would come out different. As your Honor is also correct in that wasn't the factual issue that has been raised in this case or came up during negotiations. I think everybody made the presumption that since the subcontractor did the work, they were the ones who were actively liable, and they basically conceded.
But we don't know because we don't have a jury verdict.
We don't know that, Your Honor.
Well, they wouldn't have been entitled to indemnity if there had been active negligence.
Exactly.
Yeah. But let me ask this question. And which Florida case do you say supports the proposition that if a judgment for 1/6 had been entered in this case, and let's say that the custom cabinets only had $500,000, and the insured, the contractor, had paid the first $1 million, and you paid $600,000, that first $500,000 goes to you as opposed to the contractor. Which Florida case says that?
I don't have that case on the tip of my tongue, but it would be a case involving not a case of an SIR, because admittedly there's no such case in Florida, but there are cases involving primary and excess insurance, which talk about the excess carrier being reimbursed first. Right. And we're analogizing this to that situation, since in fact the policy calls this self-insurance. And by the way, that Your Honor had brought up the Bordeaux case in Washington, and indeed that's essentially the same facts, and it comes out differently than we propose that this case come out. But the reason we feel that's so is because the Bordeaux case, whether it's the correct law in Washington or not, did not analyze the case consistent with Florida law. Because under Florida law, we're looking simply at a contract case. We're looking at how the risk is allocated in this contract, how the right to indemnity rights are allocated in this contract. What the Bordeaux case did is they went to other concepts dealing with the nature of insurance and whether or not the uninsured motorist statute had a definition of insurance and whether other statutes defined insurance. And because they found that because of this, the primary layer, the self-insured retention, didn't amount to insurance, therefore that in and of itself allowed for the application of the made whole doctrine on the theory that, well, the insured always gets reimbursed first. But no matter how insurance is defined elsewhere on earth, this policy calls the first layer self-insurance. This policy is all that's an issue in this case. And whether you call it insurance or not, the risk is allocated according to that definition in the policy. The insured has the risk of the first $1 million. Your Honor asked a question about whether this would have made any difference in the premium. It's not in the record, I agree. But the fact is, I think it goes without saying, people get these policies with $1 million self-insured reduction because they pay a lot less premium.
Well, that we know, but the question of whether it made a difference in the premium as to whether there were other insurance such as indemnification insurance with subcontractors, I think it's telling at least that this policy that was in existence preceded your policy, but there's no reference to it. They're a contractor, so obviously if you were concerned about you weren't excess insurance in a traditional sense. They had to do everything for till the first $1 million went out, right? It's not like you. So
there wasn't two insurers that were looking at what was going on. And I guess my concern is that they went out and did something for their benefit, and now it seems that you're saying, well, no, but that was for our benefit too. And the question we're dealing with here is that if there's not enough money for both, who gets it first, right? That's all. I mean, that's what we're talking about.
The answer, Your Honor, is it sort of depends on the way insurance works in these cases, which is the policies that are in effect at the time of the accident, of course, are the ones that provide coverage, whereas the policies or the contracts that were in effect at the time this house was built are years before. So there's no way that we could either compel them to have insurance or not have insurance, or go back and compel the contractor to have bought a policy.
Which is why it would seem to me that it wasn't really part of how you evaluated the risk, just because of what you said. You were not looking backward, and so now you're trying to take advantage of something that they already contracted to have and paid the premium on. I mean, not paid the premium. It insisted in terms of the contract that there be insurance.
Well, I don't know where Your Honor.
Well, I'm going to whether it is part of the contemplation of what the premium, what went into the premium was the fact that you didn't have to pay until the first $1 million got paid out.
Right.
That's
the indemnity provision in our policy, which is also part of the policy, is something we contemplated too in charging the premium, which is if there were any indemnity to be had, that right would be transferred to us. That too figured into the calculation of the
for money that you paid.
Excuse me?
For money that you paid, not just general indemnification.
Yes, for money that we paid.
Right.
Correct. I guess my time is up.
Well, it's an interesting issue.
Well, thank you, Your Honor.
It's nice to have good advocacy on both sides.
I want to go back to Justice Kennedy's question to me, and for a couple of reasons. One, I don't think I answered it fully, but also it was addressed in Mr. Schulman's comments. There was no transfer at the time of the loss pursuant to this policy. The policy says if the insured has rights to recover all or part of any payment we have made under this coverage part, it can be transferred. But it goes on to say the insured must do nothing after the loss to impair them. At our request, the insured will bring suit or transfer those rights to us. So it's something they even have the option to ask us to transfer them to them, or we can pursue them in their own name. Either way. So it's not a transfer that occurs at the time of the loss. It's something that might happen in the future if they make a payment and if they ask us to make the transfer.
But counsel says that if we assume this case is going all the way through to trial and we'd only had $500,000 of coverage on the indemnification claim, that they take advantage of the first $500,000 of that, because they would have then paid out. You would pay $1 million, and they would kick in $600,000, and they get the first bite. And he says that's consistent with Florida law.
He also candidly admits this policy could have been written better.
Well, I understand that, but I mean, is he correct? Do you agree that that's the status of?
No, I think this policy.
Which case would you then say is controlling to say that the insured would receive the benefit of the first $500,000?
The Chanel case that we've cited, Judge, it affirms the fact that made-whole doctrine is good law, and Florida says that.
Okay.
Because when you don't have a provision in an insurance policy or some statute that says who's got priority, in this case an insurance company has greater priority than my client in a limited fund, then we get it.
Okay.
And I would say to you that the one way they could have written this policy better, if they wanted to write it better for themselves or write it better in the future, they could say in a limited fund scenario, we get made whole before you get made whole. You could put that in a transfer of rights provision, but they did not.
Are you contending that any particular provision in the policy is ambiguous?
I'm not, Judge. Okay.
Are there policies that have that language in, standard policies that have that language in there?
There are policies that say, for instance, one of the policies cited by opposing counsel, I think it's the forecast case, that talks about what can be used to meet an SIR requirement. And they limit what you can't use to meet the SIR. I think that effectively gets to the same issue, and that's what Justice Kennedy was asking me before about how these questions are related. I think that has the effect of getting them where they want to go. If they say, like in that case, you can't use money that you receive as an additional insured to meet it, okay. an additional insured can't pay the SIR for a named insured. Those kind of things can get them around the issue. But again, I think the better way for them to do it, if they really want to get around the made whole doctrine, to say specifically in the policy that it's abrogated. And they didn't do that here. Out of time. Thank you.
All right. We thank you both for your arguments. That's the last case of the day and of the week. So the court is now adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.